Gadigal Nation, and I pay my respects to their elders past and present. This evening's seminar is co-hosted by Melbourne Law School's Centre for Corporate Law and Obligations Group. On 12 June, the High Court of Australia handed down its decision in Australian Securities and Investments Commission against Cobelt. In this 4-3 decision, the majority of the High Court held that an informal, expensive and largely undocumented credit scheme known as BookUp, provided by Mr Kobelt to the Indigenous residents of the remote South Australian APY Lands, was not unconscionable under the ASIC Act. The decision has generated considerable interest and has been the subject of extensive media coverage, including by the ABC and major newspapers. Our seminar this evening brings together 4 highly qualified speakers to discuss the implications of the High Court decision. Our first speaker is Professor Jeannie Patterson. Jeannie is a professor at Melbourne Law School. She teaches and researches in the areas of contracts, consumer protection and consumer credit law, as well as the role of technological change in these contexts. In her presentation this evening, Jeannie will outline the facts of the case and discuss the findings on the breach of the National Consumer Credit Code. Our second speaker this evening is Dr. Michelle Sharp. Michelle is a barrister who practices primarily in the areas of general commercial and regulatory law, specialising in contracts and consumer protection law and disciplinary hearings. She regularly appears in all jurisdictions. Michelle is the author of the book Unconscionable Conduct in Australian Commercial and Consumer Contracts, published in 2018. In her presentation, Michelle will comment on the High Court decision in terms of legal doctrine. Our third speaker is Nathan Boyle. Nathan is Senior Analyst, Indigenous Outreach Program at the Australian Securities and Investments Commission. Nathan is a descendant of a Wiradjuri people from central western New South Wales. He sits on the reference group for the National Indigenous Consumer Strategy, is on the editorial panel of the National Indigenous Law Bulletin, chairs the Indigenous Advisory Board of the Financial Rights Legal Centre, and formerly sat on the Indigenous Advisory Group of the Indigenous Financial Services Network. Nathan provided evidence on behalf of ASIC in the Indigenous round of hearings at the Financial Services Royal Commission. In his presentation, Nathan will discuss ASIC's work relating to BookUp and its emerging work to support products and services that are effective and appropriate in remote communities. Our final speaker is Gerard Brodie. Gerard is the Chief Executive Officer of Consumer Action Law Centre. He began in consumer advocacy as a policy officer and solicitor with Consumer Law Action Victoria before working as a senior policy officer with Consumer Action. He then worked with the Brotherhood of St Lawrence as a senior manager financial inclusion. Gerald returned to Consumer Action in 2011 to lead the Centre's policy and campaigns work before being appointed CEO. Gerard has represented consumers on a number of bodies, including the Australian Competition and Consumer Commission's Consultative Committee, the Australian Securities and Investment Commission's Consumer Advisory Panel, and the Australian Energy Regulator's Customer Consultative Group. Gerald will discuss possible law reform options following the High Court decision, focusing in particular on the prohibition on unfair trading. Our first speaker then, Jeannie Patterson.
And thank you everybody for coming tonight. I'd particularly like to thank Ursula from Consumer Action Law Centre who prepared our slides, and Esther Taylor from Melbourne Law School who has coordinated this event amongst many others. So the case arose out of a BookUp scheme run by Mr Mr Kobelt out of his general store Nobby's, which was in Minterby in the southern APY Lands. And Minterby is just past Cooper Pedy on this map up here. Nobby's, which actually is now closed down, was one of 3 general stores in Minterby and was primarily patronised by the Anangu people from the APY Lands. And as an aside, the whole future of Minterby at the moment is subject to question because the lease the lease of the town has actually been withdrawn as in dispute. The relevant customers of Mr Kobelt's BookUp scheme were and remain extremely poor, with very low levels of financial literacy. Minterby itself is located several hours drive from the Indigenous communities at Mimili and Indulkana, thank you. And it's over 1,000 kilometres from Adelaide. No mainstream banking services are available on APY Lands, and the closest banking or credit facilities are in Coopapedy, Alice Springs or Port Augusta, and those are each a considerable distance from the APY Lands or any of the community centres in those lands. Food and other essentials are available at community stores at Mimili and Indulkana, thank you. For cars, the Anangu people would have to go to Alice Springs or to Nobby's. So Nobby's was the general store at Minterby, and it was some distance from both of the townships and a considerable distance from Adelaide. A significant part of Mr Kobelt's business at Nobby's was the sale of second-hand cars, and obviously given the large distances that these communities are operating under, cars are an essential part of the community practices. Effectively, all of Mr Kobelt's car sales were made to the local Indigenous people, and the sales were made or completed through a program of informal credit known as BookUp. And BookUp was a form of credit that was only extended to the Indigenous customers of Mr Kobelt at his Nobby's store. Under the BookUp system, Mr Kobelt required his Anangu customers to provide their debit card and their PIN number. Cobelt would retain both of these for the period of time over which the debt of the car was repaid. Mr Kobelt would withdraw all of the funds from the accounts of his customers and deposit them in his own account in order to pay down the debt. And he would time the withdrawals to the morning on which their Centrelink payments were made. In fact, he often didn't know how much was being paid into the account, so he'd just do a trial and error to allow him to withdraw all of the money that was paid into those accounts. And he'd do it really early, first thing in the morning, so that the money could be withdrawn. Mr Kobelt would return some portion of the funds to his customers in the form of goods at Nobby's, a system known as Book Down. He also allowed purchase orders for other stores on APY Lands, for which he'd charge $10 to provide the purchase order, and he'd provide cash advances in some instances at about a 10% interest rate or charge. In the relevant period, which is from 2010 to 2012, 105 car sales were completed using BookUp. Mr Kobelt withdrew $900,000, almost $1 million from his customers' accounts, and it's not actually clear how much of this was actually returned to the customers. Mr Kobelt gave evidence that he would allow his customers store credit of no more than 50% of their withdrawn funds. So he'd withdraw the funds, he'd withdraw all of the funds that were deposited into the accounts, he'd withdraw 50%, and then he would withdraw all the funds, and then he'd allow the customers to spend down about 50% of those funds. He would only allow the customers to pay down those funds in amounts of $100, $150 or $200, so small amounts. Mr Kobelt said he did this to ensure that his customers did not spend all their money at once. This aspect of the scheme was said to respond to issues of demand sharing or humbugging in the Indigenous communities. Now, one of the aspects of the case that we'll probably talk about later was evidence given by Dr. Martens, an anthropologist who travelled to the APY Lands and interviewed Mr Kobelt's customers, or some of Mr Kobelt's customers. This evidence was relied on by all the courts to support their findings. In this evidence, Dr. Martens stated that and I'm quoting now, the Anangu have adapted their values and practices to accommodate those of the market economy through the personalisation of financial transactions. In other words, the Anangu customers prefer to conduct financial transactions through the use of brokers, such as storekeepers. The face-to-face contact involved in the supply of BookUp as distinct from reliance on paperwork, was perceived by the Anangu interviewees, according to Dr. Martin, as consistent with their customs. Dr. Martin drew attention to the importance of motor vehicles in the communities, and he also identified the perceived advantages of the BookUp scheme in combating these problems of a boom and bust cycle, which is where resources are exhausted in the relevant income period before it's over, and the pressures of demand sharing or humbugging, whereby community members pressure others to share their resources. So if you like, the evidence was that BookUp was an income management scheme. A substantial part of the customers' entitlements were actually used to pay credit charges and other fees. The cars sold by nobbies were essentially second-hand cars, usually had done 20,000 kilometres. Their value was between $4,000 and $5,000. The credit charge for the vehicles was between $1,000 and $2,000 per vehicle, which correlates over 12 and 24 months to 43% interest and 22% interest respectively. Justice White, in the first instance decision, accepted that it did not appear the customers were aware of the credit charges. There was a lack of clarity in the BookUp and book-down arrangements due to Mr Kobelt's poor documentation of the scheme. Receipts from Mr Kobelt's withdrawals would be stored in plastic bags until full, usually discarded after 3 months. Mr Kobelt kept a diary in relation to the BookUp transactions. Its entries were opaque, incomplete, and generally difficult even for the court's forensic accountant to understand. Now, these records were attached to the pleadings. They weren't relied on by the court. Just notice the little annotations on the records. And remember Dr. Martin's evidence about trusted brokers, such as storekeepers. The full court accepted White's conclusion. There was no suggestion that Mr Kobelt maintained his records dishonestly. At first instance, Mr Kobelt's operation of the scheme without a relevant credit activity licence was found to contravene Section 29 of the National Consumer Credit Protection Act, and civil penalties were imposed. It was this action that actually shut down the scheme because it was unlicensed. It is worth noting in passing, before I turn over to Michelle to talk about unconscionable conduct, that Mr Kobelt's contravention of the National Consumer Credit Protection Act is no mere technical breach. It disregarded the very law that was designed to protect credit consumers. The licensing regime imposes conduct and reporting obligations on persons who engage in credit activities, as well as specific pre-contractual disclosure or truth in lending requirements. Substantial responsible lending obligations, a process for hardship variation, relief against unjust transactions and unconscionable fees and charges, and a degree of price regulation with caps on interest rates and charges. ASIC also brought an action that the scheme contravened the prohibition on unconscionable conduct in Section 12CB of the ASIC Act, which is up here. At first instance, White held that the BookUp scheme did indeed amount to unconscionable conduct. It was an unconscionable pattern of conduct. On appeal, the full court overturned this decision. In the appeal to the High Court, ASIC argued the full court was wrong to treat the willingness of Indigenous customers of Cobell as excusing what otherwise would have been unconscionable conduct anywhere else in Australia. The appeal was dismissed by a narrow 4-3 majority. Sorry, I've got ahead of myself in the slides. And I will hand over to Michelle now, who will speak about the decision.
Thank you very much. In Cobell, Justice Ireland quipped that the concept of unconscionability is about as useful to a lawyer as the concept of a small brown bird is useful to an ornithologist. For those lawyers who hope that the High Court one day offer a field guide by which to spot statutory unconscionable conduct, Cobell must be something of a great disappointment. Although Justice Gageler complained that hard cases test and sometimes strain legal principle, the tensions in Cobell perhaps have more to do with how the appeal was framed than the facts of the case. Understanding how ASIC approached the appeal is not about bagging ASIC, which admittedly has become quite a fashionable thing to do post-Royal Commission, but about understanding the limitations of Cobell as a precedent or as proof of the inadequacy of the statutory prohibition to protect consumers. But let's begin at the beginning. Let's begin with the provision. Each member of the High Court describes or otherwise approaches Section 12CB as prescribing a normative standard of conduct. This standard is informed by accepted standards and community values which can be found in the matters enumerated in Section 12CC, common law and equity, among other sources. Chief Justice Keifel and Justice Bell cite Chief Justice Alsop in Pakioko, who identified the relevant values as consisting of certainty in commercial transactions, honesty, the absence of trickery or sharp practice, fairness when dealing with customers, the faithful performance of bargains and promises freely made. But, more importantly for the Kobelt appeal, Chief Justice Alsop also identified the values to include the protection of the vulnerable, especially from those who would victimise, predate or take advantage. Their Honours noted that it was this value with which the appeal was principally concerned. ASIC appealed the decision of the full Federal Court on 3 grounds. Briefly, these grounds focused on the special disability of Mr Kobelt's and Anungu customers, of which ASIC said Mr Kobelt took advantage. ASIC argued that the full Federal Court erred in overturning the primary judge's finding that Mr Kobelt's conduct was unconscionable by giving undue weight to essentially 3 matters. These matters are, first, the Anungu customers' basic understanding of BookUp and their voluntary entry into those contracts, or more broadly, their freedom to contract. Second, the incidental benefits of the BookUp system arising from the historical and cultural norms and practices of the Anungu community. And third, the trial judge's finding that Mr Kobelt acted with a degree of good faith and that he did not act dishonestly. In the course of submissions, ASIC argued that it was possible to fall below the statutory normative standard by simply taking advantage of a person's special disadvantage, that a finding of predatory or exploitative conduct was not necessary. Further, where there was no undue influence or trickery or dishonesty, those factors should remain kind of neutral in the weighing up of conduct to determine whether the conduct was unconscionable. Now, the differences between the plurality and the dissenting decisions centre on how each judge understood or approached the matter of advantage taking, or on the flip side, freedom to contract, and the anthropological evidence that ASIC adduced at trial on the Anungu society and culture. Chief Justice Keifel and Justice Bell rejected ASIC's submissions on advantage taking and adhered instead to the authorities on the equitable doctrine of unconscionable conduct. Those authorities require that an unconscientious advantage be taken of a special disability. Their Honours considered that in determining whether Mr Kobelt had taken an unconscientious advantage of his Anungu customers, it was relevant to take into account the absence of any undue influence, pressure or trickery by Mr Kobelt. Likewise, the absence of dishonesty was also a relevant consideration, although their Honours pointed out that moral obloquy was not required to find unconscionable conduct. For Chief Justice Keifel and Justice Bell, the absence of any unconscientious advantage by Mr Kobelt was determinative of the appeal. Their Honours concluded that Mr Kobelt had not taken advantage of his Anungu customers because they understood the basic features of the BookUp contracts and they had freely entered into those contracts because the terms suited them for reasons stemming from their cultural norms and not their position of special disadvantage. Justice Gagler comes to the same conclusion but by a different route, by focusing instead on freedom to contract. Justice Gagler includes in the statutory normative standard respect for the dignity and autonomy and equality of individuals. including for the cultural diversity of communities. In addition to the matters noted by Chief Justice Keifel and Justice Bell, Justice Gageler points out that the BookUp system had operated consensually for a long period of time with little complaint. And underscoring the voluntariness of the BookUp system, Justice Gageler notes that Mr Kobelt's and Anungu customers could have at any time ended the contract by either closing down their bank account or diverting their money elsewhere. Amusingly, Justice Gageler took the opportunity to express regret at his use of the term moral obloquy in his decision in Pakioko, but maintained that for conduct to be condemned as unconscionable, it should be conduct that falls well outside societal norms of accepted commercial behaviour. Justice Keane, though, had no such reticence about the term. He was the lone judge out of all of the judges who asserted that for conduct to be unconscionable, it had to exhibit a high level of moral obloquy consistent with predatory conduct. Justice Keane considered that Mr Kobelt's conduct was not predatory for essentially two reasons. The BookUp system met the needs of a peculiar market, his words, peculiar market, a market not of Mr Kobelt's own making. And Mr Kobelt was not shown to have obtained any unfair advantage. Justices Nettle and Gordon and Justice Eidman deliver fiery dissenting decisions. Their Honours' decisions depart from the plurality in the way that they approach the issue of the voluntary entry into the BookUp contracts. Justices Nettle and Gordon considered that Mr Kobelt's and Anungu customers were so vulnerable that they were unable to protect their own interests, and the anthropological evidence in fact helped to identify and explain that vulnerability. Justice Eidman dismissed the issue of voluntariness altogether, noting that Mr Kobelt's customers were not offered any alternative form of credit to BookUp, and that in any event, the real issue was Mr Kobelt's conduct, that is, the manner in which he offered BookUp credit and how he administered the system. Another noteworthy feature of the dissenting decisions is that they appear to stray somewhat outside the narrow submissions of ASIC in their description of the applicable normative standard. Justice Eidman descends into great detail about the legislative history of the provisions to conclude that unconscionability should be uncoupled from equity to be more broadly defined to include unreasonableness. Justices Nettle and Gordon refer to the legislation and case law in Australia which condemn conduct that has the effect of tying a purchaser to acquire products from a particular seller. Their Honour's identification of a free market as a relative norm against which to measure Mr Kobelt's conduct demonstrates, I think, a missed opportunity or error by ASIC in its chosen case theory. Instead of focusing mainly on the vulnerability of the Anungu customers, ASIC could have instead loaded up the normative standard with many more relevant norms. As with Lux, these norms could have been easily plucked from other legislation or codes that already sought to regulate consumer credit and plainly embodied accepted community standards for those transactions. For instance, the statutory values embodied in the National Credit Code that Professor Patterson just took you to could have been called upon. At the hearing of the High Court of Appeal, ASIC's counsel was actually quizzed by the bench about alternatives to Mr Kobelt's BookUp system, that being in fact prevalent in the area. ASIC's counsel acknowledged that a BookUp system that complied with the National Credit Code could not have been unconscionable. In addition to the National Credit Code, ASIC could have also called upon the values embodied in the unfair contract term provisions of the ASIC Act. Mr Kobelt's unfettered discretion to determine how his Anungu customers spent their own money would likely have compared poorly to those values. When the underlying facts of a case seem instinctively to us to be unconscionable, it is easy to criticise the legislation or even the court when a claim of unconscionable conduct fails. But consideration needs to be given to the way that the case was run. The lesson, I think, from Cobell is that it is not enough to paint a sad picture of vulnerability or unhappy outcomes. Statutory unconscionable conduct is more than a feeling. It is the measuring of conduct against accepted community standards and finding that that conduct falls grossly short. Now, this leads me to address, by way of a rough sort of conclusion, to two related matters in the Cobell decision that may have caused in some a lingering disquiet or confusion. The first is that, properly understood, taking into account the Ununga customer's voluntary entry into the BookUp contracts was about taking into account all of the circumstances in Mr Kobelt's conduct. The voluntary aspect of the conduct also formed part of a consideration of whether Mr Kobelt had taken unconscientious advantage of his customers. But consent in itself does not otherwise cure or legitimise conduct that falls well short of community standards. That is because the provision is expressly directed at prohibiting conduct that is unconscionable. Justice Santamaria and Scully put it best when he drew a distinction between conduct and consequence. Justice Santamaria observed that good conduct might have inadvertently unhappy consequences, but by sheer stroke of luck, bad conduct might produce beneficial consequences. The consequences of conduct are not in themselves determinative of whether conduct is unconscionable in breach of the legislation. Second, and somewhat related to Justice Santamaria's observation, a consideration of Ununga culture and society was, again, about taking into account all of the circumstances of the conduct and whether Mr Kobelt had taken unconscientious advantage. The fact that some Ununga customers derived cultural benefits from BookUp would not have saved Mr Kobelt's conduct from being found unconscionable if it fell grossly short of community standards. Further, the High Court's consideration of Ununga culture and society could not, in my view, properly be taken to inform a different, perhaps lower normative standard from the wider Australian community, applicable only to the Ununga community. The legislation, in my view, simply does not contemplate a multiverse, if you like, of normative standards. And Cobell is not a High Court precedent for this. Well, while Cobell is not the precedent we perhaps all hope for to better help us understand statutory unconscionable conduct, it still, I think, has much to teach us, but mostly about how we should be running such cases.
Good evening, and thanks very much for the invitation to participate in this event tonight. It's really great to see such attention being given to the issue of informal financial agreements, and specifically BookUp and the way that those agreements impact on people in Indigenous communities and how regulations might apply to those agreements. It's also exciting to see so many people closely considering the consumer protection provisions under the ASIC Act and the implications of the High Court's decision on statutory unconscionability. And I'm really looking forward to hearing Jared talk about some of the thinking that he's done around this. But as a Wiradjuri man with family connections in central New South Wales, I'd like to begin by acknowledging the traditional honours of the land that we're meeting on today, the Wurundjeri peoples of the Kulin Nation, and thank them for their ongoing custodianship of country. And I also would like to acknowledge that it's NAIDOC Week, which is a week of celebrating our cultures, and our cultures are the longest continuous cultures on earth. But it's also a time for us to reflect on our very long histories of our cultures, the 60,000 plus years that we've been here, and what's happened over the last 250 years. And as you would all know, the theme of this year's NAIDOC Week is Voice, Truth, Treaty, and they are three of the principles that came out of the Uluru Statement from the Heart. And I'll just speak very briefly about that before I go on with my comments. Constitutional recognition of Aboriginal and Torres Strait Islander people has been something that's been on the agenda for quite some time, with very little progress being made towards a definitive change to the Constitution. So Aboriginal and Torres Strait Islander people took it upon themselves to have conversations around the country to come up with a set of values that Aboriginal and Torres Strait Islander people would accept in terms of constitutional recognition. And they are having a voice to Parliament, being able to seek Aboriginal and Torres Strait Islander people's views on the laws that impact on them, having a truth or reconciliation type function established to talk about some of the things that did happen in the past and some of the negative treatment of Aboriginal and Torres Strait Islander people, and then implementing a treaty that does that gives light to the sovereignty that Aboriginal and Torres Strait Islander people still have. But back to tonight's event now, I've been asked to speak to ASIC's work relating to BookUp and to the emerging work to support products and services that are effective and appropriate in remote communities. Before I talk about my experience working at ASIC as a senior analyst in the Indigenous Outreach Program, I've been asked to say that the views that I present are my views and they're informed by my personal work and life experiences, and I don't speak on behalf of ASIC. In my introductory remarks, I'll touch on three things. So ASIC's work in relation to BookUp, where to, in regards to BookUp post the Cobell decision, and then I'll talk about the importance of putting Indigenous consumers at the heart of any reform. So ASIC's work with BookUp operations. BookUp operations and the lack of regulation applying to how they're conducted have been a concern for consumer advocates and regulators for decades. ASIC released its first public report highlighting the potential for consumer detriment, called BookUps and Consumer Problems, in 2002. There have since been several other reports by government departments, and following the implementation of the first National Indigenous Consumer Strategy Action Plan in 2005, all state and federal consumer agencies have identified BookUp as a key priority issue. In 2015, ASIC released a second report on BookUp, which found that BookUp operations, despite the great attention that's been given to them by a range of consumer advocacy agencies, are still prevalent across Australia, and there are providers in most states and territories, predominantly operating in remote Aboriginal communities, and that BookUp in the communities which it has found is an entrenched service. BookUp reports and discussion papers released by government departments and consumer advocacy agencies over the last decade or so have had two consistent themes. First, they've highlighted the reasons why Indigenous consumers use BookUp. Primarily, that BookUp provides access to an otherwise unavailable form of short-term credit, which can be relied on by many Indigenous people to manage their money between paydays and in periods or times of crisis. So it allows access to essential goods and services when people have already spent their income. And second, the reports have highlighted the potential detriment to consumers through poor BookUp practice. These reports and discussion papers have also noted the difficulty posed to law enforcement agencies and regulators in addressing all but the most significant instances of consumer detriment under the existing legislative frameworks. Prior to the commencement of the National Credit Act in 2009, regulation of credit was the responsibility of the states, save for the Uniform Consumer Credit Code, which was enacted as template legislation in Queensland and was replicated in acts in each state and territory, commencing operation on 1 November 1996, except for Western Australia, which wanted to be a little bit different and implemented quite a similar framework, but did not enact the Uniform Code until later. The Uniform Consumer Credit Code is largely replicated as Schedule 1 of the National Credit Act, and the Act also implements a uniform national licensing regime for credit providers. The House of Representatives Standing Committee on Aboriginal Affairs noted in late 2009 that whilst BookUp remained a significant problem in most states and territories, ASIC was taking a lead role as the national regulator of consumer credit from November 2009, and that this held greater promise for consistency in BookUp regulation. However, regulating BookUp practices through the National Credit Act has not been the panacea it was envisaged as in terms of its ability to regulate poor BookUp practices. The National Credit Act prescriptively identifies the types of credit arrangements that will and will not be captured. In order to prove that a particular BookUp operation is captured by the National Credit Act, a law enforcement agency must present evidence to the court to show that the service is being provided on certain terms, including that a fee or a charge is made for the provision of that service. And as you can see from the picture that was in the slides earlier from Jeannie, it's quite difficult if a BookUp provider wants to operate in such a way that they are charging a fee and that they can keep records in whatever way that they want, to be able to prove to the satisfaction of the courts that a fee in fact was charged. Because if you write down food $900, there's no way for a regulator like ASIC to come and look at your books and records and to determine what aspect or what amount of that total actually is a charge for the provision of the service. ASIC provides guidance on best practice BookUp for providers, which includes guidance about best practice record keeping for store managers. However, because there's no formal regulation mandating the way BookUp is conducted, record keeping arrangements vary from store to store, with some storekeepers keeping best practice BookUp records and other stores keeping no records at all. Where a BookUp provider keeps no records at all, as I've said, it's incredibly difficult to determine if it is regulated credit under the National Credit Act. So as has been highlighted this evening already, the recent High Court ruling was not in ASIC's favour, finding that the way that Mr Kobelt was operating his BookUp service did not amount to unconscionable conduct under the ASIC Act. We did still maintain the unlicensed credit provision aspect of our case. That was not overturned by the High Court. The High Court did not grant leave for that appeal to be heard. But regardless of the outcome of the unconscionable conduct proceedings, this was an important matter for ASIC and an important matter for the broader legal community. This was the first time that a BookUp matter has ever gone to trial. There have been many other attempts by consumer law regulators around the country to get litigation up around BookUp, but most of them have been settled at mediation. ASIC was able to obtain evidence, as was said before, that Mr Kobelt was charging an undisclosed fee for the provision of BookUp on motor vehicles, and that he was engaging in unlicensed credit provision. And that then allowed us to have a second avenue to test whether or not unconscionability under the ASIC Act would be able to address those same elements that we thought were poor practice for other providers. And the High Court's given us our answer, that statutory unconscionability is not the solution. I've been asked many times since the decision was handed down whether I'm disappointed in the outcome. And leaving aside questions about what the decision might mean in regards to statutory unconscionability, and there are many people who are much more qualified than me to talk about that, I'm not disappointed. Because though we didn't get the outcome that we were hoping for, the decision sparked this conversation about appropriate financial services for Indigenous Australians in remote areas of Australia. And it's very encouraging that so many Australians, including all of you here tonight, are considering fairness and adequacy of reimagining a system that can meet the needs of Indigenous Australians, and perhaps more than that, perhaps it's a system that supports financial well-being and stronger communities. So where to in the post-Cobelt landscape, what can we do to make sure that the things that we thought were below community standards in the way that Mr Kobelt operated his BookUp system do not continue to cause detriment for other people using BookUp services? I've been concerned for some time that the existing legislation was inadequate to effectively and efficiently address misconduct in BookUp operations, and the High Court decision about Cobell supports these concerns. Over the last several years, we've been consulting with Indigenous communities about these concerns, and we formulated with those communities some of the key things that the communities would like included in any rules that may be introduced to enhance consumer protections for people accessing BookUp services. And the thinking around potential reforms that might enhance those consumer protection provisions is actually well progressed. We're not just starting now, we've been consulting with communities around what appropriate rules for BookUp might look like for some years. There have been suggestions to consider amendments to the National Credit Act. However, in my opinion, the National Credit Act specifically excludes a range of informal credit provision, including most BookUp operations, and probably does so for good reason, because it wouldn't be a good situation for the National Credit Act to be regulating me lending $20 to one of my friends. And having any kind of amendment to the Credit Act that lowers the threshold of what kinds of credit are captured may have a whole host of unintended consequences. Another mechanism that's been considered to address the potential for consumer detriment in BookUp provision is the Community Stores Licensing Scheme. Under this scheme, BookUp is already prohibited at over 100 stores in remote communities in the Northern Territory. However, in my view and ASIC's public view, BookUp is seen as an essential service by many Aboriginal and Torres Strait Islander communities, and we don't support a ban on BookUp. The Community Stores Licensing Scheme also operates under the Stronger Futures in the Northern Territory Act and is only applicable in the Northern Territory. That was the legislation, the follow-up legislation to the Northern Territory emergency response. The scheme is also limited because it's a food security mechanism, and it therefore only applies to stores selling food, drink or grocery items, where the store is considered to be an important source of those items for an Aboriginal community. There are a number of other possibilities that could still be explored, including amendments to the Corporations Act, capturing BookUp, or the implementation of a licensing regime that required all BookUp providers to be licensed unless they were complying with best practice principles. This may also be an area where ASIC could use the product intervention powers that we've recently been given to introduce rules around the use of BookUp, given that BookUp is associated with risks and includes the risk of significant consumer detriment. But regardless of what happens next, it's essential from my perspective that Indigenous consumers are at the centre of those reforms. ASIC is committed to proactively identifying opportunities to understand what works in remote communities and to better understand the impact that legislative change may have on people we are trying to protect. Effective and lasting reform will need to be informed by Indigenous communities. It seems to be quite common that Indigenous consumers consider BookUp to be an acceptable and indeed necessary form of credit. However, Indigenous communities have also indicated to us that they are not happy with the way that many BookUp systems are currently operating. And they've said that any change in practice, any kind of rules and consultations that we've run so far have been in the APY Lands, Unconscionable lands, across the Kimberleys in Western Australia, and later this year we'll be conducting more formal consultations on the potential rules. And the rules that have been suggested by the consumers that are impacted on by BookUp services should include a ban on the holding of debit cards and the associated PINs by BookUp providers, which just seems to make common sense. The implementation of record-keeping requirements so that consumers can keep track of their level of debt at any point in time, and that where a consumer feels like they haven't been treated the right way and wants to make a complaint to ASIC or to another regulator, that it is possible for us to inspect those books. The consumers that we've consulted with have expressed a want for a maximum level of indebtedness or a cap to be put on the level of credit that can be offered through BookUp schemes. Many consumers have told us that they are shocked when they find out how much they do owe their BookUp provider, and that that's something that worries them. So working out what an appropriate limit would be in terms of the Indigenous communities that utilise this service is certainly important. And they would also like the ability to negotiate the quantum and frequency of BookUp debt repayments. That's not a concept that is unique to, it would not be a concept that would be unique to BookUp. There is the protected income amount that already exists regarding debt repayments for people who are in receipt of welfare payments. But BookUp is a system unique to Aboriginal communities, and the BookUp operations that we hear concerns about are most often located in or near remote Aboriginal communities. These are the same communities that have developed these rules. It's a problem that is unique to these communities, a service that they rely on, and a set of rules that they've called on the government to implement. So ASIC's certainly supportive of working further towards law reform in this space. And again, thank you very much for coming along to this presentation during NAIDOC week, and look forward to the panel discussion.
Is that on? Yep. Thank you to the law school and Ian and Jeannie for inviting me along to speak tonight. And I'd also like to acknowledge the traditional owners of the land in which we meet, the Wurundjeri people of the Kulin Nation, and pay my respects to their elders past, present and emerging, and acknowledging their ongoing relationship and custodianship of the land, remembering this is land that was never ceded. The focus of my talk will be on what this decision might mean for the development of a prohibition on unfair trading. We've already heard a bit about the detail of the decision and its discussion on statutory unconscionable conduct. I thought I'd just make two simple points about that, which I think tell us that there needs to be a further discussion about what else. So first, the High Court decision was a 4-3 divided decision. And that tells us that the meaning of statutory unconscionable conduct is not agreed upon by the highest judges of the land. I think it's most stark between the positions of Justices Keane and Edelman. According to Justice Keane, there is necessarily, quote, a high degree of exploitation of a special disadvantage in cases of unconscionable conduct. But according to Justice Edelman, the prohibition does not require there to be a special disadvantage or any undertaking of conduct that took advantage of that special disadvantage. Widely different positions. Second, on the majority's reasoning, the bar for statutory unconscionable conduct is very high. According to Justice Gageler, the conduct must be so far outside the social norms of acceptable commercial behaviour as to warrant condemnation. Further, the social norms seem to be less about promoting community standards of fair dealing and more about prohibiting conduct that is outright predatory, involves victimisation and or unconscientious, a much higher standard than fair trading. So the debate about the need for an unfair trading prohibition in Australia has actually been waging for a long time. In 2008, the Productivity Commission considered the issue in its review of Australia's consumer policy framework. The Productivity Commission noted that, quote, conceptually, a broad provision against unfairness is attractive because it can avoid prescription of specific types of unfairness and, in theory, does not need to be continually adapted as new commercial expressions of unfairness are discovered. However, ultimately, noting jurisdictions where such provisions have been enacted were also accompanied by detailed rules prescribing certain conduct, it found that a general provision against unfairness might be more conceptually neat than practically useful for consumers. The issue was again examined in the context of the 2016 review of the Australian consumer law, with the reviewers seeing merit in such a provision. That report recommended that the issue be further explored to assess whether there is any overlap between general unfair trading and existing protections in the Australian consumer law. This exploration has in fact been kicked off just in the last few months, with the New South Wales Office of Fair Trading releasing a tender for a legal consultant to conduct research on the issue on behalf of all the consumer law regulators. The issue has also gained some traction recently in the context of the ACCC inquiry into digital platforms. In its preliminary report released in December last year, the ACCC raised concerns about the way in which disclosures are provided by digital platforms like Google and Facebook, and the way in which our personal information and data is used by digital platforms, and the way in which consumer consent is obtained. The ACCC said, despite likely consumer harm, the general provisions in the Australian consumer law were not well adapted to deal with this sort of harm. For example, there is generally some sort of disclosure such that the conduct isn't considered misleading, but it's hidden in terms and conditions that we don't necessarily read or understand. And the conduct is possibly not so immoral as to be unconscionable. Noting that comparable jurisdictions, including the EU, UK, USA, Canada and Singapore, all have prohibitions in relation not only to misleading and unconscionable conduct, but also unfair trade practices, the ACCC's report asked whether Australia should have such a prohibition here. And that report their final report will be apparently released next week, so it'll be interesting to see if that position remains in the final report. So what would a prohibition on unfair trading look like in Australia? I want to cover 4 aspects in considering this question. First, I'll touch on the existing directive on unfair trade practices in the European Union. Second, the US prohibition on unfair, deceptive and abusive practices. Third, our existing unfair contract term regime. and finally reflect on fairness in the context of the recent Banking Royal Commission. The EU Directive on Unfair Commercial Practices adopts a tiered structure, but starts with a general prohibition on unfair commercial practices. It then provides that a commercial practice is unfair if it is a misleading action, if it's a misleading omission, or if it's aggressive. Then there is a more detailed blacklist of practices which are deemed to be unfair. There are two parts of the EU framework that I think is useful to pull apart. First, its definition of general unfairness adopts the concept of professional diligence. And it also considers whether the conduct distorts the economic behaviour of the average consumer. The concept of professional diligence is important because it describes a level of skill and care which a trader must reasonably be expected to exercise, commensurate with honest market practice. It might go so far as requiring a general duty of care for traders. Second, the EU approach is strong on misleading omissions. While our existing prohibition on misleading conduct does extend to omissions, it only does so where there is a reasonable expectation of disclosure. And the courts have found that in many contexts, there's no expectation on businesses to inform customers that, for example, prices are going to change at some point. Whereas that might be considered a misleading omission in the EU context. Next, I want to make a few comments about the US prohibition on unfair, deceptive and abusive practices, known as UDAP. The fairness aspect of this provision has three limbs. First, offending practices must cause, or be likely to cause, substantial injury to consumers. Second, that injury must not be reasonably avoidable by consumers. And third, the injury should not be outweighed by countervailing benefits to consumers or competition. I won't go through the detail of all the analysis associated with the provision, but a key question it raises is whether the act or practice hinders a consumer's decision making. For example, not having access to important information could prevent consumers from comparing alternatives, choosing those that are most desirable for them, and avoiding those that are inadequate or unsatisfactory. The way in which Mr Kobelt's customers were bound to the store would clearly be unfair under this construction. Another important aspect of the US conception of unfairness is it deals with unfair practices endemic in a market. For example, if almost all market participants engage in an unfair practice, a consumer's incentive to search for better terms elsewhere is reduced, and the practice might not be considered reasonably avoidable, and therefore might be prohibited. The US provision also examines whether the act or practice is injurious in its net effects. That is, the injury must not be outweighed by consumer or competitive benefits. The common example to think about is perhaps that despite this being unfair, it's delivering lower prices to everyone. I do think that's actually a helpful consideration, taking a community-wide view to look at the impact of the conduct for the broader community. I should say, though, that most of the business conduct that consumer advocates are concerned about as being unfair ends up being more costly, not less. I'll now touch briefly on our existing Australian law on unfairness, the prohibition on unfair contract terms. A key test in considering whether a term is unfair is whether it is reasonably necessary to protect the legitimate interests of the party advantaged by the term, usually the business. While this aspect of fairness is recognised in terms of contracts, it does not extend to other trade practices, for example, unfair marketing or information provision that does not amount to misleading conduct. An example of unfair marketing that is not necessarily misleading might include the common practice of energy retailers, which market discounts of different base rates in their advertising. It confuses everyone. The prohibition on unfair contract terms may not necessarily capture other unfair business practices, like using a consumer's personal information in ways that the consumer does not understand or expect to influence a product, service, design or pricing. The terms of a contract often say very little about the way a business will use personal information or are very vague. Conceived similarly to our existing prohibition on unfair contract terms, a prohibition on unfair trade practices more broadly may be pro-competitive. This is because it might encourage business practices that enable the consumer to focus on the core product or service and price being offered, rather than hidden aspects being found in product design or marketing practices, which are not reasonably necessary for the protection of legitimate interests of the business. This in turn drives suppliers to compete on the basis of the fairness of their products and services. Finally, I thought I'd make a few comments about fairness in the context of the Hayne Royal Commission. In his final report, Commissioner Hayne identified 6 precepts that were important for financial entities, one of which was to be fair. Fairness, of course, is replicated in general duties for financial entities to provide services efficiently, honestly and fairly, which is included in both the Corporations Act and the National Consumer Credit Protection Act. And breaching that duty now gives rise to a civil penalty. Commissioner Hayne and also the current chairman of ASIC have publicly stated that fairness is doing what is ethical. They talk about doing the right thing. This, I think, is a helpful approach in seeking to influence the leaders of large firms that have reputational concerns. Think of the banks. However, I think we need to go further than this to build fairness as a basis for the competitive market more broadly. For example, it's questionable whether Mr Kobelt had much concern for reputation. Moreover, he also likely felt that what he was doing was the right thing. That's why I think that an unfair trading provision, framed as supporting an effectively competitive marketplace, will be a useful adjunct to consumer protection law. Unconscionable conduct, as we have heard, is steeped in equity and has a focus on ethics and morality. While these values and norms are important, the edges of them will always be contested. Justices of the High Court can't agree on the extent of unconscionable conduct. An unfair trading approach can supplement unconscionable conduct by adopting a more objective approach, perhaps one more based in an economic understanding or thinking. As I've outlined, the approaches in other jurisdictions examine the extent of harm or injury or loss to consumers, whether that harm was avoidable, and whether consumers were free to make informed decisions. These factors go to the outcome of a market for consumers, not just the conduct or misconduct of particular businesses. In this way, an unfair trading provision can support the overall objective of the Competition and Consumer Act to enhance the welfare of Australians by promoting competition and unfair trading and to provide protection for Australian consumers. Thank you.
Thank you, Jared. The rest of our speakers. Will we have some time for questions and comments? Yes.
Hello. I'm Aaron Gorman. I would like to acknowledge the elders past and present of all Australian nations. As you might hear, I'm not Australian myself, but I'd like to point out that in this discussion it might be quite worth considering that the provision of these kinds of services and goods are excluded from the European directive in fair trade practices because they would be considered financial services and goods, and actually they are regulated now under the Markets in Financial Instruments Directive 2. So I would just like to hear from the advocate if you think there is a significant difference in the standard between the different directives, and what the best pieces of each one you would take to maybe implement here.
Well, thank you for your question. I'm probably not as familiar with the standard on financial services in the EU law as you are. I'm actually probably most attracted to either the US conception, which I went through, or even building on the provision we already have in Australia around unfair contract terms, where And so I think that a similar approach could be taken to other aspects of trade practices, including marketing, information provision, post-sale conduct, and a range of things.
Yes.
We heard about Justice Hayne and what he said about fairness and doing what's right. But we have a judgment here where the judges can't even agree on what's right. So in that context, I throw it over to the panel. What advice do we have for directors who are sitting there and having to approve schemes like the BookUp scheme and whatnot, where Justice Elderman has a very harsh view of it and the majority think it's fine?
We'd like to open.
Well, I'll say something. I'm sure Michelle will say something. First of all, I think it's really important to look at the decision because the decision, as Michelle pointed out, is quite narrow. Because if you read the judgments of Bell, Kiefel, and Gagler, their judgments are based on the case that was put to them, and the case that was put to them was that there was unconscionable advantage taken of a special disadvantage. So they actually gave their decision on a very narrow frame. So the differences in the judgments are to some extent premised on whether they looked at the equitable doctrine or the factors that were in the legislation. Secondly, I guess I'd say that Cobell wasn't a director of a company, he was an individual running a business. Directors of companies need to think about, need to implement a system that is transparent, honest, doesn't take advantage of people. I actually think that that's quite possible. Michelle?
Yeah, I would agree with that, and of course Justice Keane as well adds voice to that and makes it quite clear that the High Court wasn't being invited by ASIC to consider unconscionable conduct more broadly, and that in Justice Keane's view, it'd be unfair to consider that because Mr Kobelt's counsel really haven't had a chance to respond to that. So I would say for those directors, they obviously need your skills, they need good legal advice. That's obviously key, but I think, and this is where perhaps ASIC took a misstep, which is easy to do in a run of litigation in terms of their case theory, and think more broadly about the legislation or codes of conduct that regulate a particular industry or transaction, and have an eye to that.
I'd certainly say that statutory unconscionability isn't off the table for ASIC at the moment. We're about to file proceedings on a purely statutory unconscionability case as well. So I think that part of the High Court's judgment was that the reason that this was, part of the reason it was not seen to be unconscionable in all the circumstances was because of the free entry of Unreal into the service with a knowledge of the basic terms of the service that they were entering into. So I think that there are a whole range of broader contexts where unconscionability still will be viewed, behaviour still will be viewed as unconscionable within the terms of the ASIC Act by the courts. But I think what this decision has also shown is that there's a bit of a regulatory gap, or there are certainly some gaps between the community standards and expectations of the kinds of behaviours and the kinds of operations that can happen and what the law currently says is illegal. And just for an argument purely on why BookUp should have reform in that space, when you have a look at the rationale behind the government's amendments to the credit legislation to bring in a greater range of protections for small amount credit contracts and consumer lease providers, the rationale that they said for bringing in greater protections was that these are products that are accessed usually by low-income consumers that are more likely to be financially vulnerable or to lack the financial understanding of other consumers. And that kind of rationale and those greater protections for small amount credit contracts and consumer leases stands in stark contrast to the fact that a service can be operated without any regulation essentially, and with far greater amounts of credit being extended to consumers who are often even more vulnerable than those that have access to consumer lease providers and to payday lenders, because the only access that Unreal will have to credit is to approach these BookUp providers that at the moment aren't required to be licensed, and apart from the general consumer protection provisions, there's no real requirement for them to operate their service in any particular mechanism. So I think that statutory unconscionability is probably an argument that is more well discussed by others on the panel than me, but I certainly think from ASIC's perspective, we're not moving away from running matters alleging unconscionable conduct in the provision of financial services, particularly to vulnerable consumer groups.
Was there a question towards the back? Yes.
Thanks so much for speaking today, guys. It's been fantastic, especially the plethora of perspectives on this matter. One fact I felt that wasn't really discussed or wasn't focused on hard enough, which I thought was a big part of the joint majority judgment, was the fact that the local Indigenous people themselves didn't have too many grievances with this system. I think it was 1 or 2 of the 117 over a period of a decade that actually had a problem with this. So I'm kind of interested in everyone's perspective on that factor, but also, Nathan, you spoke about how ASIC doesn't support a total ban on these things. What is the considerations of the local Indigenous people's experience when deciding to bring these test cases, and how much does that determine decision making going about this?
Yeah, I'm sitting on another advisory group at the moment looking at the civil law needs of Aboriginal and Torres Strait Islander people, and what that's really looking at is whether the current legal frameworks in Australia are actually an appropriate vehicle for Aboriginal people to seek justice. And I think that the way that evidence needs to be given to courts doesn't necessarily correlate with the way that Aboriginal and Torres Strait Islander communities would like to give that evidence. There's also then a strong reliance when you're looking at the acceptance of conduct by Aboriginal and Torres Strait Islander people on expert evidence, because there's not a whole lot of jurisprudence in this area around Aboriginal and Torres Strait Islander cultural preferences. So I think that whilst the evidence that was given by vulnerable consumers in court was found by the High Court to say that they were accepting of this and that they were not unhappy, stands in contrast to my experience of dealing with the consumers on the ground. And I'll step this away from Mr Kobelt's store. There were 5 other stores, 4 or 5 other stores within the same Minty leasehold operating BookUp. There are hundreds of services around the country that are doing similar things. And I have remote Aboriginal people who don't speak English come to me crying because BookUp providers have chopped up their key cards and thrown them back at them when they've asked to have them returned. There certainly were people that were not happy about the way that the service was provided, but I think that for Aboriginal and Torres Strait Islander people, many of whom this is the first or second generation of people who've had access to their own money and had access to financial services, that for them, the way that they express whether they are happy with the service or not doesn't necessarily capture the whole range of alternatives that they have to them. So people really liked Mr Kobelt. They knew that if they ran out of money before payday, they could drive to his store and he would give them a little bit of food and they wouldn't be hungry. And that was a service that they really wanted to keep. But then when you talk to UNDL about setting up a set of rules, or are there things about the service that you don't like or that you're not happy with, then UNDL will come out with a whole range of perfectly sensible, very reasonable rules and a whole lot of things that they think are inappropriate about the way that they're currently being dealt with. So I think that whilst the judgment does suggest that most of the consumer witnesses were happy, it's also, and I'll say one more thing that I'll be quiet about, it's another way about the way that courts evaluate Indigenous evidence. And there are cultural concepts like gratuitous concurrence, which is the tendency of Aboriginal and Torres Strait Islander people to agree to a proposition that's put to them, regardless of whether or not they've even understood what was said to them, let alone whether or not they agree. So it's very easy under cross-examination for a remote Aboriginal person to have a proposition put to them that lends them to give an answer that leads the court to believe they liked the service when that may or may not be the case in reality.
If I could just add to that, thank you for your question. It's a really important question, very important issue, and I suppose there's two things I'd say. The first is that when you're talking about consumer protection, you're enforcing these acts. It's very difficult generally to give witnesses to give evidence. I've done the bulk of the under quote for real estate agents. So there I'm dealing with white people who are well enough to own or sell a house, and it's incredibly difficult for them to give evidence, or to encourage them to give evidence. And needless to say, a more vulnerable group. The second thing is that we haven't really, in the space of time, dealt with is Dr. Martens' evidence. I certainly don't have your level of understanding or expertise, but even in reading the case, I have grave reservations about that evidence. There was 117 affected consumers. I think he only interviewed a portion of that, and
he looked at BookUp generally.
Yeah.
He wasn't actually talking about that particular system. So there were all sorts of things. I mean, ASIC tried to, I absolutely agree. ASIC tried to run this as a system case, which means you didn't actually rely on the evidence of individual witnesses.
That was due to fear of individual witnesses not giving evidence.
Yeah.
And just about the experts' report, without making any comment on
So on top of that, so they actually did have, just like Unique College, which was a systems case, initially in Cobell they wanted to run a systems case alongside individual unconscionable conduct case, but then abandoned it, I think, because of that fear.
Yeah. And the way that Unconscionable wanted to give evidence, even with Dr. Martin, who was ASIC's expert, it took me a long time sitting with senior lawmen in the community to get them to understand why they had to speak to Dr. Martin without me being there. Unconscionable said, that's not how we do things. We tell one story, and why does he want to talk to people by themselves? That's not how things happen in our culture. We sit down and we all tell our story to the one person and the decisions made. So the structures and the way we have to provide evidence to court in these matters doesn't align with getting justice for those people. And I think that might have also had potentially some limitations in the conclusions Dr. Martin was able to draw, because many Unconscionable didn't want to talk to Dr. Martin because they couldn't talk to him. They didn't want to talk to him without me being there, or without someone that they had already told their story to being there.
Can I just add about the point around the lack of complaints? At Consumer Action, we provide assistance primarily to people who are experiencing vulnerability of a disadvantage of some kind. And our experience is that people don't complain, and there are a range of reasons. They don't know how, they don't know where to complain, they don't know how to frame a complaint. I was talking to one of our staff members just last week who was out working with communities, Indigenous communities here in Victoria, and people who had spent 4 months without any electricity and had never complained about it because they didn't know that they might have a legal entitlement here. So I think the lack of complaints doesn't actually indicate there isn't consumer harm. We've really got to interrogate more than just relying on consumer complaints.
And I think also in this case it's probably a feature just how vulnerable they
Indeed,
are.
yeah.
Well, I'm conscious that we actually have gone a little bit over time, so I think it's probably appropriate that I bring the seminar to close, albeit that I'm sure there are some other questions that you'd like to ask. But would you join with me, please, in thanking our 4 speakers?